All rise. We will obey. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Pouvez-vous s'asseoir?
Good morning, and could the court officer please call the case?
Thank you, Madam President. The situation in the Republic of Kenya in the case of the prosecutor versus Uhuru Kenyatta, ICC 0109-0211. We are in open session.
Thank you very much. And as usual, can counsel please introduce yourselves for the record, starting with prosecution.
Madam President, Your Honors, the Office of the Prosecutor is represented this morning by Mr. James Stewart, Deputy Prosecutor, Mr. Benjamin Gumpert, Senior Trial Lawyer, Adeshola Adeboyejo, Trial Lawyer, Mr. Sam Lowry, Trial Lawyer, Shamiso Mbizvo, International Cooperation Advisor, Haidu Dok, Legal Assistant, and I am Fatou Bensouda, Prosecutor. Madam President, Your Honors, I am here today because, as the Chamber has observed, the case is at a critical juncture, and I thought that it would be right to be present in person. I have complete confidence in Senior Trial Lawyer, Mr. Benjamin Gumpert, who has been leading the trial team in this prosecution, and I am sure that Your Honors will understand when I defer to him in speaking for the prosecution on matters of detail which may assist the Chamber. I thank you.
Thank you. Defense.
Thank you, Madam President. I'm Stephen Kay of Queen's Counsel with my co-counsel, Gillian Higgins. In court with me today is my instructing solicitor, Mr. Desterio Oyatsi, Mr. Ken Ogetto, and then I have the team Kirsty O'Sutherland, Katie Hovington, Ben Joyce, and Tom Ophoff, who are all part of the defence team, and I'm with Uhuru Kenyatta in court today.
Thank you very much. Legal representative of victims.
Good morning, Madam President. Fergal Gaynor, Caroline Walter of the OPCV, and Anushka Semi for the victims. Thank you.
Thank you. And again, as usual, in order to assist translation and transcription, I would like to remind everyone to speak slowly and to pause for several seconds in between speakers. Today, we will be sitting in the morning until 12 o'clock. And the courtroom has also been reserved in the afternoon between 2 o'clock and 4 o'clock, if necessary. In terms of structure of status conference today, the Chamber has a number of specific questions for each of the parties and participants, which we will address first during the first part of the status conference. After that, there will be a second part, an opportunity for each of the parties and participants to make additional submissions you wish to make. In order to give you an indication of timing for those submissions, additional submissions, the prosecution and legal representative will each be allocated no more than 15 minutes. The defense will be allocated 25 minutes. to encompass sufficient time should Mr. Kenyatta wish to address the Chamber directly. Any such submissions by the accused should be done within this allocated time frame for general defense submissions. If Mr. Kenyatta does not wish to speak, and he is under no obligation to do so, the defense time shall be modified accordingly to 15 minutes, which is the same as the prosecution and legal representative. Like yesterday, I again remind all counsel to be concise and focused in your submissions, to be courteous at all times, and to wait until given the floor before speaking. And Mr. Kenyatta, we note your presence in the courtroom today, and we welcome you. This hearing has been convened to address matters of fundamental importance, which impact directly on your rights as an accused, as well as the interests of victims and witnesses in this case. As you are aware, the Chamber is seized of a request from the prosecution for the indefinite adjournment of these proceedings, and from the defense on your behalf for termination. A decision granting either request would have profound implications, and it is in that light that the Chamber has required your attendance at this hearing. The issues to be discussed today may include submissions regarding the potential relevance of your dual status. That is the fact that you are both an accused person before this court and the head of state of a state party from whom certain cooperation has been requested by the court. However, you are present here today solely in your capacity as an accused individual. The Chamber may choose to direct questions to you or to counsel on your behalf. You are under no obligation to answer the questions directly. You may defer entirely to your counsel to respond to any question. But if you choose to speak, you are not under oath. This is status conference, and the submissions will be considered in that light. Moreover, you may speak only in your capacity as an accused and may not make statement either of a political nature or in your official capacity. Have I been clear enough? Do you understand, Mr. Kenyatta? Can you say yes and no?
Madam President, this was all discussed last night between myself and my client, and I would answer questions on his behalf in court today. We were aware the court may take an approach and offer the right of response to him, but having considered matters and in view of the nature of the proceedings, I will be answering questions on his behalf, and he does not choose to make a statement today.
Thank you very much. As I said, this status conference was ordered on 19 September 2014. The purpose of the hearing is to address matters arising from the prosecution's request for further adjournment of the proceedings and the defense request for defense-related request for termination. As I indicated, we will start with a number of specific questions from the bench. First, prosecution. In your notice of 5th September, 2014, which is filing 944, you provided two main reasons why you do not consider it appropriate to withdraw the charges. One is the alleged failure of the Kenyan government to comply with the cooperation request. And the other is the position of the accused as the head of that government. We note also that you indicated in the hearing yesterday that you consider the cooperation with Kenyan government to have reached a deadlock. Now, can you please explain what relationship you see, if any, between your request under Article 87.7 of the statute and the request for an indefinite adjournment?
It is an indirect relationship. The request for the adjournment is the substantive decision which we ask the Chamber to make. We submit that it is justified by the two reasons to which Your Honour has referred. We submit that it would be wholly inappropriate for a case to be withdrawn where there has been obstruction of the proper inquiries which the justice of the case required to be made. That is the substantive step that we ask the Chamber to take, irrespective of any other finding that it may make. The second finding, the finding under Article 87.7, the finding of non-compliance, is a finding which is indirectly related. We submit that if it is right that there has been a failure on the part of the government of Kenya to comply with its duties under the treaty, and if it is right that this court is satisfied that there is no explanation, no proper excuse for that failure, it is a necessary step for this court to take to sanction that failure. It is, if I may put it this way, akin to sanctions which a court may impose where there has been an interference with the course of justice or a contempt of court. Such a finding that there has, for example, been a contempt of court is linked to the proceedings because it arises out of those proceedings. But it is an indirect link. It is not a step in those proceedings in itself. It is a necessary and proper disciplinary measure, if I can call it that, which the court takes in order to mark the fact that one of the parties to litigation, or in this case, a concerned body concerned in the litigation, has failed in its duty to the court, and that the court takes what steps it can to sanction that failure. That is the relationship which the prosecution submits exists between the two orders which we ask the court to make.
Thank you very much. In that case, prosecution, am I correct that the prosecution is not consider fixed period of adjournment as an option? For example, if a referral under Article 87.7 were to be made, adjournment, there is an option that adjournment might be granted pending the Assembly of State Parties exhausting all measures. Am I right that you are not, for the prosecution, this course of action is not an option?
One could imagine a number of dates. Let's recall where we started with this procedure. Your Honours effectively accorded the Kenyan government 6 whole months to comply with a request which in the end the court found was an appropriate one. That didn't work. We could now imagine a further 6 months, but it would be, I respectfully submit, a pointless repetition of what the Chamber had done before. Or one could imagine a date such as at the date of the next elections in the Republic of Kenya. That too might be a feasible date. I confess that I hadn't thought of the possibility of fixing a date by reference to whatever determination the Assembly of States Parties might come to. But in the end, Your Honours, the only realistic date is the date when the government of Kenya does what it is bound to do under the Rome Statute. We don't know what that date will be. It is mere speculation, and therefore I submit the best course is to adjourn the case effectively sine die, that is to say, without fixing a date, but making it plain at the same time that the event which will trigger the end of that adjournment is compliance by the government of Kenya.
In that case, prosecution, and I also note that at the status conference yesterday, you yourself indicated that the prospect of obtaining sufficient evidence, even if the Kenyan government cooperate fully, remains speculative. Could you identify any specific legal basis or jurisprudence to support your request for an indefinite adjournment? Could you please comment more specifically on what you consider the legal basis for such an adjournment?
Your Honour, I'm not going to be able to provide either case law or specific powers within the statute which, in black and white terms, give the Chamber the power to make an indefinite adjournment. The Court undoubtedly has the power to regulate its own proceedings, and to do so taking into account the interests of justice and fairness to the parties. I hope that that is an uncontroversial statement which I make there and doesn't require specific reference to the Rome Statute or the rules. It would be bizarre if the law were anything other than that. In exceptional cases, that will require the Court to take exceptional measures. Domestic jurisdictions will permit exceptional steps to be taken when the justice of the case requires them. And I would respectfully submit that this Court, this Chamber, must apply exactly the same criteria. The grant of an adjournment is uncontroversially something which is within the Chamber's power. There is no law that requires the grant of an adjournment to nominate a specific date on which that adjournment will come to an end. Indeed, it might be observed that a strict interpretation of the Chamber's current position is that the case is adjourned and no date is fixed for the trial or the termination. We have in existence, as we speak at this moment, an adjournment without a day being fixed, that is to say, sine die. So the short answer is no, I don't present the Court with any case law or any statute which specifically says the Court may adjourn a case indefinitely. But I submit that it is plain to everyone that that course of action may be appropriate where exceptional circumstances demand, and I submit that these circumstances are well and truly exceptional.
Thank you, prosecution. I just want to add that in our last decision to adjourn or vacate the trial date, it was in the same decision we decided to convey this status conference to further discuss. So I don't see the situation the same as indefinite adjournment. But anyway.
I shan't argue with the court. If that's Your Honour's judgment on the matter, then so be it.
Thank you. Regarding the relevance of the position, still with prosecution, regarding the relevance of the position of the accused as head of state or head of government, first, do we understand correctly that the prosecution is not alleging at this time that the accused has deliberately interfered with the collection of evidence?
There is no evidence of any action or inaction that he has taken or refrained from in the course of the period between our request for cooperation and today. And so the answer to Your Honour's question is yes, we make no allegation, we have no evidence on which we could properly do so.
So your argument is that the accused should, by reason of his official status, be precluded from raising the issue of undue delay in the context of requested adjournment. Is that correct?
The argument the prosecution would make against any argument of undue delay would be based upon the fact that we asked for the things which the court has ruled we're entitled to 2.5 years ago. That is, I submit, the compelling argument against any suggestion that there has been undue delay on the part of the prosecution. It might, I suppose, be added as a supplementary argument that since 2013, the accused has had a specific duty under the Kenyan Constitution, if I recall it's Article 132(5), to ensure that the Republic of Kenya complies with its international obligations. And it would lie ill in his mouth in those circumstances to say, I am unfairly affected by a state of affairs for which, although he may bear no personal responsibility, he is constitutionally responsible. So I wouldn't put that argument as the first argument countering any suggestions of undue delay, but I would place it as a supplementary argument which undoubtedly should influence any finding that Your Honours might make on that subject.
Thank you very much. With all what you explained so far, but still, prosecution, do you really consider that an indefinite adjournment consistent with the accused rights and as well as integrity of the proceedings and the interest of justice under the circumstances where the underpinning evidence has fallen below the standard required for trial?
Yes, the prosecution has come to that conclusion. Principal amongst the arguments which the prosecution advances are the interests of justice, one of the trio which you mentioned a moment ago, Madam President. Where an accused comes before any tribunal, in this case the International Criminal Court, accused of very serious crimes, and where the investigation of those crimes, what I have called in previous pleadings the basic building blocks of establishing a case where the accused is alleged to have financial and organizational involvement, have been impeded by a third party, there is obviously a very great interest in sending the message, well, let me not start there, in the court making it plain to all parties that such interference, such obstruction, will not bring proceedings to an end, that the court will be resolute in pursuing the case which has been brought before it, despite any obstruction in investigations. That would be the case even if there were not the extra dimension to which you, Madam President, have already referred. That is to say, the dual status of this particular accused person. Because the party, the body that we say has been failing to cooperate in the way that it is required to, is the government of Kenya. Mr. Kenyatta has been part of that government for many years, but since 2013 he has been the head of that government. And if there were any doubts about the court making a resolute finding to demonstrate to those obstructing its work that they will not succeed in doing so, if there were any doubt about the propriety of such a course, those doubts would be removed in this particular case, this exceptional case, where the accused person has a specifically defined constitutional duty to ensure that no such obstruction takes place.
Thank you. Judge Henderson has a question.
Can I ask you not to put the microphone on, or alternatively I'll take my headphones off?
Yes. In answer to the presiding judge, you indicated that you couldn't really refer to any authority for this indefinite adjournment.
Yes.
And you essentially referred to this as an exceptional circumstance, and that such an application would be grounded in the interest of fairness and interest of fairness to the respective parties.
And the interests of justice.
And interests of justice.
Yes, generally.
Right. Now, and you also refer to a domestic type situation in which domestic courts would permit this exceptionally. Now, of course, this is the difference. This is an exceptional circumstance, or this is different. Here we have, perhaps I should start this way. The essential question I want to ask you is, how is this compatible with the regulation 60, which essentially would require, if I can just direct your mind to it, if at any stage in the proceedings the office, this is under the rubric withdrawal and amendment of charges, because as you would apprehend in a domestic situation, it is always open to a prosecutor to withdraw a charge and to come again when they have the evidence. This is a measure which is open to a DPP or any prosecutor. Regulation 60 provides, if at any stage of the proceedings the office considers that the evidence available, including both the incriminating and exonerating evidence, does not support an element of the charges pleaded or supports a different charge, or that any charge pleaded otherwise cannot be pursued, in particular due to the individual circumstances of the accused, then the office shall promptly seek to either, and one of the options is to withdraw the charges. How is your submission compatible? Because we'd have to be persuaded ultimately by your submissions. How is your submission for an indefinite adjournment compatible with this?
This was a question which the court asked effectively at the very first hearing after we asked for an adjournment and for a finding of non-compliance. I was specifically referred to this regulation. In my respectful submission, the court has already effectively demonstrated that it is satisfied that an adjournment of the trial, in other words, that the prosecution is not, by reason of this regulation, duty-bound immediately to withdraw, that an adjournment is, or may be, an appropriate course of action in the peculiar, perhaps unique circumstances of this case, where a state party is failing to provide cooperation. The court has already permitted an adjournment of the case for 6 months and permitted the prosecutor effectively not to withdraw during that period. So, in brief, without repeating myself too much on the submissions I made last time, the key word here, or the key words are, the office considers that the evidence available does not support the charge. We're not yet in a position to make the consideration which the regulation requires us to do before we withdraw. We know that there is evidence in existence. We do not know what that evidence will indicate. As I have stated previously, it might exonerate or inculpate. But at the present time, the actions of the government of Kenya are preventing us from making the consideration to which this regulation requires. The evidence, the material, is available. It could be provided. We know that there are 33 months' worth of bank statements which have not been provided under compulsion or otherwise. We know that material is available, but we can't consider it. Why? Because we are being obstructed from doing so. In those circumstances, in my submission, a further adjournment, this time without a date being fixed, other than the clearest possible indication that the adjournment will cease when the government of Kenya abides by its duties to the court, would be, we submit, both fair and entirely in accordance with Regulation 60, to which the court has referred me.
Ultimately, the exercise is one of carefully balancing the rights of the accused person and also the rights of the victims, which the court must pay the closest heed to, because ultimately it is a balancing act, having regard to the two. As far as I'm concerned, has to be, I have to understand though, is, does an indefinite adjournment cure that? To keep the court's resources engaged, as opposed to the OTP's resources, that is the chambers. Ultimately, what is to prevent, as in a domestic type situation, a withdrawal? You pursue your charges, you pursue your investigations in light of the concession that you do not have sufficient evidence to take you to perhaps half-time, what in the common law would be referred to half-time, prima facie case, and then come fresh by the reinstitution of fresh charges.
There's nothing to prevent the course taking that course of action. Speaking frankly and without having considered the matter at length, it seems to me that that is within a range of reasonable decisions which the court could make. So let me make that concession. But in this case, as Your Honour has indicated, the court has to balance what is the most appropriate thing to do. And there are other courses of action within that range of reasonable decisions which the prosecution submit better fit the circumstances of this case. In particular, the prosecution submit the interests of justice should be paramount here. I don't mean to say that the defendant's rights should be ignored for a moment, but the interests of justice should, I submit, be the most important consideration in Your Honour's minds. And it would not be in the interests of justice, and I risk repeating myself here, so I shall be brief, for the court to make a ruling which will effectively be interpreted as the court saying, if a country sticks out for long enough, obstructing proper inquiries being made by the prosecutor, despite the court having made a finding that that obstruction is improper, then the case against the person that country wants to protect will go away. Any such ruling would be capable, plainly capable, of that interpretation. And that would be a disastrous interpretation. It would be capable of being understood to mean that states parties with a legal duty to act in a particular way can torpedo the course of justice.
Judge Freeman.
Thank you. Mr. Kamper, in my view, the purpose of any adjournment considered by the court should be some better perspective, I would call it, of the case. I think court also should very carefully consider duration of such adjournment, and even yourself, you said that from your point of view, 6 months adjournment probably shouldn't bring any fundamental improvement. It was my understanding you don't believe in any fundamental improving in such a duration.
Your Honour's right, yes.
Yeah. So in such a case, frankly, I think it's not clear to me why you believe then in case of indefinite adjournment, such a measure could bring any improvement.
No, Your Honour, that's not the reason. It is not because I think that an indefinite adjournment will act as a bigger lever in moving the position of the government of Kenya that the prosecution asked for an indefinite adjournment. It is to prevent the injustice, which I say would be represented by a decision not to grant an adjournment, and which I expanded upon in my answer to His Honour Judge Henderson just a moment ago. It is that injustice which I say can only properly be avoided by the grant of an indefinite adjournment. It has to be, or I submit, it can only practicably, reasonably be indefinite because we have run out of hooks on which we can hang any particular date. In answer to Her Honour Judge Ozaki, I suggested, not entirely seriously in respect of all of them, various dates which we could consider. I think implicit in her question was to find out the date on which the Assembly of States Parties will consider this matter, if there is a referral, and make that the terminating date. I suggested the date of the next general election in Kenya. But all of these dates are not going to provide any realistic greater prospect of what we would say is ultimate compliance with the government of Kenya's treaty obligations. The only realistic end point, it isn't an end point, the only realistic order to make if the court is minded to adjourn, is to say, we don't know when this case may resume, but we believe that justice demands that it shouldn't be terminated now on these conditions in the light of this obstruction, if that is the finding you make. And therefore, the only realistic order we can make is to adjourn the case without fixing a date. There may come a time during the future, who knows when it will be, when this court, you three judges remaining seized with this matter, will say, I know not, in 5 years' time, whenever, enough's enough. But I would respectfully submit that whilst this continuing failure on the part of the government of Kenya is still fresh, and while this accused person is still the head of that government, that day will not come.
And my second and the last question for the moment, do you think that at this moment of proceedings, the Assembly of State Parties could or should play any role in solving the issue?
Well, Your Honour, I think that probably comes back to some of the issues I touched upon in response to, I think it was the very first question that Judge Ozaki asked me. I would hope that if I am right in my assertion that there's been a failure on the part of the government of Kenya to cooperate properly, that they will come to their senses and a proper recognition of their obligations under the Rome Statute sooner rather than later. I can't well, I could, but it's not going to be a legal submission, and it's not going to be a submission which is helpful to the court, to speculate on what kind of effect the discussion by the Assembly of States Parties might have upon the intentions and actions of the government of Kenya. Political commentators can do that far better than I. Let me simply say this. The prosecution does not ask you to condition this adjournment or to fix a length for this adjournment with reference to any action the Assembly of States Parties may take. If this court judges the government of Kenya to be in breach of its duties, it will be for the Assembly of States Parties to discuss that matter and decide what, if any, reprimand or sanction they impose upon the government of Kenya. But those have only an indirect impact upon this case.
Thank you very much.
Thank you. Now I would like to turn to legal representative. Thank you, Mr. Gumpert. Mr. Gaynor, you have also made submissions regarding the relevance of the official position of the accused. Therefore, we'd like to ask you a couple of questions on this point. First, do you consider there to be a distinction between Mr. Kenyatta's de jure position as head of state and any actual active interference with the collection of evidence? And relatedly, is it your position that the latter circumstance of active interference can be substantiated in this case, bearing in mind the responses of the prosecution to my almost the same question? And in this regard, I hasten to add, We have already noted the examples cited in your written filings of conduct by the accused, which you allege may have had a chilling impact on cooperation with the court. And there is no need to repeat those submissions. And we have also noted your submissions regarding the de jure and de facto power of the accused. Therefore, if your position is that there has been deliberate interference, is it based on these circumstances which you mentioned in your written filings, or do you have any further substantiation? Mr. Gaynor.
Thank you, Madam President. On the first point, it's clear that there has been no evidence presented to the court that the accused has specifically taken action to destroy evidence or other acts which would ordinarily fall under the rubric of obstruction of justice or perverting the course of justice. That's not the argument that I've presented to your honours. My argument is that the accused controls an entity. That entity is unlawfully withholding evidence which your honours have directed to be provided. If the accused were the director of a company, your honours had ordered that company to deliver evidence to you, and if the accused did not take any action to ensure that that company delivered the evidence to you, in many jurisdictions, he would be liable for an obstruction of justice investigation and possible prosecution. Now, what I have said, and I know your honours don't want me to repeat myself, what I have said is that the accused is without question the most powerful and influential person in Kenya. Yesterday, the Honourable Attorney General said 4 times that 72 hours was all that was necessary to turn over telephone records, bank records, I think he might have said land records. I'll have to check the transcript. But it's quite clear from what the Attorney General said that really it's not a time issue involved, that the evidence is in Kenya, it can be turned over very quickly. The accused has a constitutional obligation to ensure that Kenya complies with its international obligations. He has an obligation under public international law generally.
Mr. Gaynor,
Yes.
sorry to interrupt. I don't think that's what Mr. Attorney General meant when he mentioned 72 hours.
Yes, just my only point is that in terms of the time frame that he gave, 4 times I think he mentioned 72 hours as the time within which he'd be able to provide evidence if he received, in his argument, appropriate...
But it has nothing to do with the accused position as the head of government.
Right. In my submission, it does. The accused controls the government of Kenya under the Constitution of Kenya. The Attorney General can only be dismissed by one person, and that person is the President of Kenya. The Cabinet Secretaries responsible for securing the state's compliance with the International Crimes Act can only be dismissed by the President of Kenya. So it is because of his powers under the law of Kenya and his responsibility under the Constitution of Kenya that grounds my argument that he is, through his action and inaction, obstructing the provision of evidence to this court, evidence which your honours have directed to be provided.
Thank you very much. And this leads to my next question to you, Mr. Gaynor. Can you comment on the question I asked to the prosecution regarding how you consider that an indefinite adjournment of proceedings could be reconciled with the right of the accused? in the particular context of the evidence having fallen below the standard required for trial. And in this connection, we note that in your last written submission, you referred to a particular Canadian jurisprudence regarding circumstances in which a knowing waiver may be imputed. If we please, you may wish, could you expand further on this point and how you would see such jurisprudence fitting into the Chamber's decision-making process and its obligation under Article 64.2?
Yes, thank you, Madam President. In respect of authority for ordering an indefinite adjournment, I note that at footnote 183 of Your Honour's decision of the 31st of March 2014, which is document number 908, Your Honours have set out a number of instances from this court, from the ICTR and from the ICTY, where adjournments were provided, for example, pending the appointment of co-counsel for the accused, or, for example, indefinitely adjourned due to the unavailability of prosecution witnesses arriving from new travel procedures implemented by the government of Rwanda. So that in that case there was adjournment pending action by the government of Rwanda in a case in which the accused was not in control of the government of Rwanda. So I think that there is the term indefinite adjournment, as I understand Your Honours to mean it, it's not adjournment forever. It's adjournment until a specific step is taken. And in this case, in my submission, that step can be taken at any moment by the accused in this case if he directs his government to comply with Your Honours' directions of the 31st of March and 29th of July. Another point I'd like to make is that if in a domestic jurisdiction an accused absconds from the jurisdiction, if he takes off to Spain or if he goes into hiding within his own jurisdiction, in many jurisdictions, and I'm willing to do research and bring a written filing on this, the case is adjourned until the accused is either arrested or voluntarily turns himself in. In this case, the accused has not absconded, but the parallel is that the accused has voluntarily, in my submission, through his inaction, created the delay which is in this case. The delay in this case is non-compliance with the revised records request. That non-compliance is not due to any action of the prosecution. It's not due to any action of Your Honours. It's due exclusively to action of the government of Kenya, which is under the total control of this accused. Now, turning to the Canadian cases that Your Honours asked me to elaborate on.
Just briefly,
yes,
if you may.
Yeah, I'll keep it as short as possible, Madam President. Essentially, my argument is, and it emerges from the Supreme Court of Canada, an accused cannot complain of delay in the proceedings if he is solely or primarily responsible for that delay. And the main obstacle in this case, as I said, is non-compliance with the revised records request. Securing compliance with the international obligations of Kenya is an obligation of the President of Kenya under both the Constitution of Kenya and under international law. The one person who can remove the principal obstacle to progress of this case is the accused. So, in summary, and I'll end with this, the accused's failure to remove that obstacle is not only unlawful, both under domestic and international law, his failure to do so also amounts to a waiver of his right to an expeditious trial, and that waiver will last for as long as he fails to secure compliance by Kenya with its obligations under the Rome Statute.
So your view is that, your submission is that the indefinite adjournment can be reconciled with the right of the accused, even under those circumstances, I mean absconding or deliberate obstruction, even when the prosecution explicitly admitted that the evidence have fallen below the standard required for trial.
It is, because it is the accused who is in total control of the delay in this case. And remember, we're dealing with an absolutely unique case here, where the accused controls the government, which is unlawfully obstructing the prosecution's access to evidence. It's something which is, by its nature, unheard of in a domestic proceeding. The only previous domestic case that I could find was the one I mentioned on the 5th of February, which was the Nixon case at the United States Supreme Court, where the Supreme Court ordered Nixon, then the President of the United States, to deliver evidence which could be inculpatory against him, and following his resignation, President Ford pardoned him. So that is the only direct precedent I could find. But it remains the case that no matter how powerful the accused, even if he's head of state, Your Honours must remain firm in ordering his government, under his control, to deliver evidence which is relevant to criminal investigation against him.
Thank you. Judge Henderson.
Thank you.
Thank you, Mr. Gaynor. The application to adjourn a case indefinitely, you would accept, is a very exceptional circumstance. Now, unlike the jurisprudence from the ICTY, ICTR, the Rome Statute does provide a place at the table for victims. So this is hence your locus. My question is a direct one. Would one of the possible options following Regulation 70 would be a withdrawal of the charges with the leave of the court? Would such a situation, with a view to continuing investigations and perhaps at the appropriate stage, if it is appropriate, the reinstitution of proceedings, would such a course of action occasion any prejudice to the victims in this case?
Thank you, Your Honour. If there was a substantial likelihood that the prosecution would reopen the investigation against Mr. Kenyatta following withdrawal of charges and following the delivery of evidence, I can see a great deal of merit in that arrangement. On the basis of everything that I've seen, it seems to me that if these cases are terminated, the government will see once again that obstruction of access to evidence is a viable strategy. That policy will continue, and it will be harder than ever for the prosecution to get the evidence that it needs. Secondly, I know that the prosecution has many other cases before it. As victims, we don't have the choice of focusing on an easier case. We don't have the choice of focusing on a case where there might be more evidence. The prosecution has that choice. For all I know, and I need to emphasize, I'm speaking on behalf of the victims, for all we know, the prosecution might choose to prosecute an easier case. They might choose to abandon this case. So from the victim's perspective, we would much prefer for Your Honours, if you are considering an adjournment until the Assembly of States Parties procedures for securing cooperation have been fully exhausted, we would much prefer for Your Honours to take that route, and I can see a great deal of sense in that route. But to allow the prosecution to withdraw the charges completely, I frankly think that will be the complete end of the justice process for the victims in this case.
Thank you.
Now I would like to turn to the defense. And thank you very much, Mr. Gaynor. However, as a preliminary matter, the Chamber wishes to note a point of concern with your filing 945, and I am referring specifically to its paragraph 22. And our concerns relate to the public referencing of conditional material and the unqualified repetition of allegations which the Chamber has already ruled upon and found to be unsubstantiated. But I will not go into further detail in this session because of time limitation. But please bear this guidance in mind and exercise great care in future filings. And returning to the substance of the matter at hand, legal representative of victims and to some extent the prosecution submit that the defense should be precluded from raising the issue of undue delay because of the accused position as head of state, whose international obligations in the form of cooperation with the court are in issue. How does the defense respond to that particular point?
The first matter that has to be looked at in answering that question is whether there has been unjustified delay or obstruction. And for my part, I was struck by the submissions of the Attorney General yesterday and the correspondence that had been produced between the prosecution and the government of Kenya that showed the very active steps that they had taken in furtherance of the inquiries of the prosecution. So the matter hinges as to whether there has been either delay by the government of Kenya or any failures on their part. And I wondered if the responses of the government of Kenya had properly been taken into account. I can go through each of the 8 heads that were submitted upon yesterday. I don't know whether that would be met with favour by Your Honour as something you would like me to do.
Not in this status conference.
Not in this status conference.
No.
Because it seemed to me that the matters raised by the Victims' Council this morning on the very same issues alleging obstruction wasn't obstruction at all. It was the nature of the requests that were the problem. And the responses by the government of Kenya in my submission had clearly dealt with the natures of the requests and provided answers. So from that position there, we have that issue that has to be determined. Prosecution this morning are alleging that the fault for the failure of the case is the government of Kenya as being the issue. And in my submission, that is not something that a proper inspection of the materials would actually produce a reasonable conclusion upon. Be that as it may, we have a position here where my client is head of state, but he is also an accused with rights. There are no allegations at all of obstruction by him or of me in relation to any of those inquiries by the prosecution. And we have put forward before this court several instances of quite extreme cooperation by us. So his position as head of state is only material if there is evidence that he has done something wrong in pursuance of this case. At the moment, the report to him by the Attorney General and an inspection of the materials that took place yesterday reveal that his government is cooperating with the office of the prosecutor, who is failing to recognize the negative answers are not a failure on their part to cooperate, but an answer to their particular lines of inquiry. So the head of state issue, as far as he is concerned, is perfectly satisfied. In relation to his private capacity as an accused, he obviously does not interfere in these matters because he has personal rights and he has a lawyer that has told him not to interfere in these matters, and that is the clear position. So in response to the question, Your Honour, my submission is that the evidence reveals that the head of state issue that has been brought to bear as an allegation is not in fact founded upon substance, and all heads of state rely upon the competence of ministers to discharge their duties, and the Attorney General yesterday referred to the correspondence between the parties, which in my submission showed that cooperation. Issues were raised as to whether there'd been delay of 1 month. Why no response? Well, the fact of the matter is the bodies were researching the evidence that they'd been asked to look at. They didn't come back with a response the next day to say there is no evidence. They waited till they'd looked at their files and considered the matter. So that is my submission upon it.
Thank you. Mr. Kay, next question to you is, you have previously, I think it was last year, sought a permanent stay of proceedings on the basis of alleged abuse of process in this case. And now you are requesting a termination of the proceedings. What differences, in your view, does the defense see? What differences does the defense see between those two remedies?
The grounds upon which the stay of the proceedings for an abuse of process are entirely different from the grounds that we present to the court that require a termination of the proceedings. The grounds for the abuse of the process was as a result of particular evidential matters, which the court is well seized of, that we submitted went to the quality and the corruption, if you like, of the investigation in this case and the presentation of the evidence. So that was a very distinct area. We moved on from there when it appeared that the witness who had been relied upon by the prosecution had changed his story. He admitted lying. Another witness had withdrew, had changed his story, made allegations against the prosecution in relation to his conduct. And the position we had there was with an admission of the insufficiency of the evidence to support the case. And that insufficiency of the evidence immediately brought to bear the responsibilities under Regulation 60 concerning the future conduct of the case. So the initial matter was not because it was based upon any admission by the prosecution, but was something we sought judicial interference upon. I don't mean interference in a derogatory way, but an intervention, if you like, into the conduct of the proceedings, whereas the issue concerning the sufficiency of evidence is a bold and plain matter, and had been the culmination of a number of significant events going to the quality of the evidence in the case. So a different matter entirely.
Thank you very much. May I would like to ask excuse me. Prosecution and legal representative, do you have any comments on this specific issue? Thank you, Mr. Kay.
That is to say, the difference between a termination by the court and a permanent stay.
Yes.
Well, I understand Mr. Kay's meaning of both of those to be that the case will stop, will come to an end. In other words, there will be no adjournment of any kind. And I also understand him to mean that there shall be no further proceedings in respect of any similar charges. Inasmuch as I understand him correctly, I don't believe there is any difference between those two things. They simply arise, no doubt, as he has just explained, at different stages in the proceedings and therefore get different labels. The prosecution, of course, says that if the case is to be withdrawn and thus terminated, that should be strictly without prejudice to the bringing of any further proceedings on precisely the same subject matter.
Mr. Gaynor, on the same point.
Thank you, Madam President. Yeah, the two terms to me appear to be more or less synonymous. The most important point to be made by any court would be to clarify whether the termination is with or without prejudice. So I would agree with Mr. Gumpert on that. It's important to clarify, are charges dismissed with prejudice or without prejudice? Thank you.
Thank you, Mr. Gaynor. Relatedly then, prosecution. Does the prosecution consider there to be a difference between the remedies of a conditional stay of proceedings and an indefinite adjournment?
I'm embarrassed to say that I was speaking to my learned leader when Your Honour began that question.
I can repeat.
I'm very sorry to trouble you to do so.
Does the prosecution consider there to be a difference between the remedies of a conditional stay of proceedings versus indefinite adjournment?
I'm trying to give a coherent and brief answer. I think that must depend upon what the stay is conditioned upon. Let me venture an understanding. Let us say that the court decided it was going to stay the proceedings and that the condition on which the stay would be lifted would be the court being satisfied that the government of Kenya had now complied with its duties to cooperate. If that were the nature of the conditional stay, I hazard a guess it might be, that would, in real terms, be absolutely no different from an adjournment, which was expressed to be sine die, without a date fixed for the resumption of the case, but with the clear statement by the court that that date would be the date on which it was satisfied that the government of Kenya had complied with those obligations. Those will be two labels for functionally exactly the same thing.
And prosecution, I know that prosecution has answered that question before, but can you repeat, what is your position on the authority of the chamber to terminate proceedings at this stage?
Let me not misquote. Article 64 of the Rome Statute sets out the functions and powers of the trial chamber. It's long, it's familiar, so I shan't read it. Save for Article 64 sub-article 6F, which reads in relevant part, in performing its functions prior to trial or during the course of a trial, the trial chamber may, as necessary, F, rule on other relevant matters. The plain intention of the drafters was to give the judges the power to control their own proceedings, and where specific instances were not covered by the article, to give the judges, to give the chamber, the power to rule on any particular matter where the interests of justice demand a ruling, and to make any appropriate ruling demanded by the interests of justice. That is the authority which you have. It is couched in the broadest and most general terms. But I do not believe there is any greater and more specific, any lex specialis, to use the jargon, which specifically relates to indefinite adjournments or indeed adjournments of any type.
Thank you very much, Mr. Gumpel. Mr. Kay, the chamber notes in your written filings, you seek a final determination of the charges. Is it correct to understand from this that the defense seeks a verdict to be entered?
Yes, Your Honour. I can elaborate on that if you would like, having given the answer. I don't want. I have an eye on the clock, but the reason is this: we got to the position of a trial about to start, and for all intents and purposes, in relation to the conduct of this case, we were at the trial stage, and it may have been that we weren't at the first day with the usual ceremony, because what happened was, instead of having that first day, we were listed just before. And so in many respects, what would have been something that could have been discussed on the first day of the date of trial did not happen. And so one has to be broad about this and robust about it. It would be an affront to common sense to say you were not entitled to your acquittal in those circumstances because the first day of the trial didn't actually happen. Really, that's an affront to justice, because the circumstances meant that the plug was pulled for the very reason that a trial could not take place. And in those circumstances, I respectfully submit to the court that we are entitled, taking into account all the circumstances of this case, the journey it went through, and the evidential matters that arose that put us in that position, meant that there had been a degrading and destruction over a period of time that should entitle that verdict of not guilty to be entered. And the court could do that precisely under the regulation referred to by my learned friend, Mr. Gumpert. We are in agreement with him upon the nature of that regulation, which refers to prior to trial as well as during trial.
But apart from that regulation, Mr. Kay, do you happen to have any authority or jurisprudence on what you have just explained?
Yes, this is a very common feature. Prosecution have no evidence, and it happens regularly in courts throughout certainly the common law world. I have no evidence, I have insufficient evidence, but I want a case adjourned. No, you cannot have your adjournment. Well, I'm not going to offer no evidence. Right, call your evidence then. I can't call my evidence. Therefore, the case is dismissed by the judge, and trying to say that technical rules can in some way prevent that, in my submission, is not in the interests of justice. And there is a broad perspective that can be looked at here that happens very, very regularly in criminal procedures.
Thank you very much, Mr. Kay. Judge Henderson?
Yes, Mr. Kay, just one question. When Judge Osaki asked you about the authority, of course you referred to the usual position in the common law in which the head of prosecution services would withdraw the case in precisely the circumstances which you described. But you would agree with me, would you not, that there appears to be a fundamental difference in that in a domestic situation, a DPP or head of a prosecution services, in a sense, has a control over the domestic investigative arm of the state. And therefore, the situation is distinguishable. And that perhaps might be the nub of the matter. Would you agree?
With respect to Your Honour, I don't, because the procedure of this court is all about an investigation. That's how we started this journey, with the investigation, permissions being given, evidence being brought to a pre-trial chamber, summons being issued, investigation continuing. There is clear control over the investigation, and there is also a clear duty in the regulations. If the prosecutor is unwilling to exercise what amounts really to a personal discretion, this court, in my submission, in the interests of justice, can intervene. And in many respects, with an international court, you can see the more likely need for that, because we have to look outside the confines of the courtroom. There are enormous political pressures on cases here, on the nature of the cases, who goes on trial, as well as the influence of victims. So we are looking at something very different here that may cause a prosecutor to put a brake upon how far that prosecutor is prepared to go, because of the wider questions of image as well as responsibility. And I remind the court that was something I said right at the start when this first arose, I think it was last February, that this would be a matter that the court should intervene upon. So in my submission, this court has a clear oversight of the prosecutorial functions which enable it to take upon itself that role in circumstances such as these. You have the admission of the insufficiency of the evidence in the case. You have issues concerning cooperation, which you will look at and make a decision upon, and I hope look at it carefully, as I'm sure the court will, that in my submission bring us to this position that the case has failed, and it has failed in a way that means there is no prospect of it going further. If the prosecutor does not intervene, you act to terminate. The prosecutor will not offer any evidence.
So you do not see a difference with a domestic situation where the head of the prosecution services can call a chief constable or a commissioner of police or whoever leads the investigations and has, as it were, a more hands-on dealing with the investigative process, as opposed to here, where the prosecution does not have any investigative arm of its own and has instead to rely on the very state party? Because this is, in essence, the complaint that is being made, as I understand it.
I see the way Your Honour is putting it. All I can say is that at Nairobi Airport, one is constantly bumping into investigators from the OTP and seeing them at hotels. So they have investigators and they investigate. And in a way, it's a bit of a fig leaf for them to hide behind, to try and say, this is not our fault that we didn't get the evidence. The case was brought after an investigation and evidence produced, which came from the national sources. And in those circumstances, for my part, at this stage, I see injustice if this court is unable to return a verdict which, for all intents and purposes, would have been there. For my part, that involves the court in not being able to take charge of the decision-making processes. Whatever the structure is not the point. The point is, it is the quality of the case. And when we consider the interests of victims and witnesses, also our witnesses are within that collective, and our victims are within that collective. And in my submission, that entitles this court to return a verdict upon where we reached in the case, and that can lie with Your Honours.
Thank you, Mr. Kay. I have one small clarification from Mr. Gaynor. You briefly mentioned about the relationship between the referral to the ASP based on Article 87.7 and indefinite adjournment. Is it your position that a finding under Article 87.7 is only of utility if it is accompanied by an adjournment?
Thank you, Madam President. I believe that it would make most sense in that environment. The entire procedure set out in the ASP documents referred to at paragraph 60, footnote 77 of filing 946, where the ASP sets out its formal and informal procedures for securing the state's compliance. They make most sense in this case if the case is still in place, instead of being an entire procedure for trying to convince the government of Kenya to provide evidence in relation to a case which no longer exists. It makes most sense in my submission if the case is still existing for the Assembly of States Parties to be in full purchase of the situation. And also I would submit, just very briefly, that every confidential filing relating to non-compliance by the government of Kenya with Part 9 of the statute should be provided by Your Honours to the Assembly of States Parties so that they have a full picture of the true extent of the Part 9 violations in this case.
Thank you very much.
Thank you.
And that brings us to the end of the first part of this status conference. And as I indicated at the start of the hearing, we will now allow each counsel to make any additional relevant submission they consider to be necessary. In your remarks, you should each summarize your respective positions, taking into account the nature of this status conference. However, of course, we do ask you to be as concise as possible and to address only the substance of the matters, which are only the substance of the matters of this status conference. But before asking each council to stand up, court officer, about the time frame, is it possible to shorten lunch break? Because we will now entering into the second phase of this status conference, and during this second status conference, we will have submission from parties and Mr. Gaynor. I think it would be better if we break now, and the court officer needs 30 minutes to change the tape. That means that we break now and resume 12:05. And after 1 hour, I think we can complete this status conference, if that suits parties and participants.
Certainly, Your Honour.
Yes.
Yes, thank you, Madam President.
Thank you very much. Then the hearing is adjourned, and we will meet at 12:05.
All rise. All rise. We will away. Please be seated. Boy was
Good afternoon and welcome back. And let us go straight to the second part of this status conference. And may I now invite the prosecution, will it be Madam Prosecutor, to make a general submission no more than 15 minutes.
Thank you, Madam President. Madam President, I will start. with the final submissions from the prosecution, and then senior trial lawyer, Mr. Gumpert, will continue. Madam President, Your Honors, there are 2 points that I want to make. One is a short one, and the other long. The short point is this: there is no middle way. Either, Madam President, you refuse any further adjournment and therefore require the prosecution effectively to withdraw, or you permit an indefinite adjournment conditioned on the eventual compliance of the government of Kenya with its duties. Any other course will simply be ineffective. As Honorable Judge Henderson has said, ultimately, it is a balancing act. The scales of justice have to come down, one side or the other. The interests of the accused alone do not trump all others. And all others, Madam President, are the rights of victims and the wider interest of justice. They are all vital components. The longer point, Madam President, that I mentioned is this. At various stages of these proceedings, the defense have suggested that the prosecution has no case, that all the evidence it once relied upon has been exploded. This is the defense submission throughout the case. But this is incorrect. There remains a considerable body of evidence that implicates Mr. Kenyatta. The prosecution has scrutinized very carefully this body of evidence, and we judge that this evidence is insufficient to make you sure. But concerns that the Chamber may have about the injustice of allowing a case to continue where there is simply no evidence can be put aside. We're going to summarize the evidence that we currently have, Madam President, and senior trial lawyer, Mr. Benjamin Gumpert, is going to do that. We will try to remain within the 15 minutes.
Thank you.
Let me do that briefly. I apologize if I go at a little pace. Witness 152 says he was present at a meeting at a hotel which was attended by Mr. Kenyatta. And during the meeting, he says Mr. Kenyatta contributed money to the Mungiki and announced that there had been an agreement with the Mungiki that they would fight on the PNU Kikuyu side during the post-election violence. That witness also says that during the post-election violence, Mr. Kenyatta approached him through a member of parliament, and the message was that Mr. Kenyatta wanted to facilitate the ability of the Mungiki to protect the Kikuyu community. Witness 428 received money and weapons from a former member of parliament on a daily basis during the violence. That person told 428 that he was acting on behalf of Mr. Kenyatta. Witness 505 received money and weapons from a former MP during the violence. He told witness 505 that he discussed the attacks with Mr. Kenyatta, that the money came from Mr. Kenyatta, and that Mr. Kenyatta was in solidarity with the Mungiki. Witness 428 corroborates, witness 548 corroborates witness 428's account. Witness 510 received money for organising violence from yet another MP.
I think you are too fast for interpreters.
From yet another MP who is alleged to have been the coordinator of the violence in Naivasha. During a meeting at a hotel in Naivasha, he contributed 200,000 shillings from his personal funds and 1 million shillings which he said came from Kamwana. That means young man, and it was Mr. Kenyatta's nickname. The money was given for funding of weapons. Witness 493 says that yet a third MP persuaded that witness and other Mungiki to join the fight, and that he later learnt that this MP was acting on behalf of Mr. Kenyatta. Witness 494 was told by a senior Mungiki that he'd received a large sum of cash from Mr. Kenyatta in early January 2008, and that that money was for the violence. And witnesses 429 and 430 both say they went to Mr. Kenyatta's house in Ishawari to raise funds for the violence, and that at that house they were given a significant amount of money. That is a total of 9 witnesses who would come before the court and give the evidence which I have summarised. Then there is material which is available both to the prosecution and the defence, arising from joint efforts in respect of telephone investigations. Mr. Kenyatta, the prosecution believes, used a telephone which ends with the numbers 891. That's evidenced by what witness 152 says, and it's confirmed by open source data freely available on the internet, and indeed other individuals to whom the OTP has spoken. Telephone data, which is in the possession of the prosecution and the defence, reveals that just 5 numbers were in contact with Mr. Kenyatta's telephone in December and January of 2007 and 2008. The data for the outgoing calls made on Mr. Kenyatta's phone has been destroyed. The only data that is available is the incoming calls, but that data alone gives rise to a number of questions. The telephone being used by former witness 12, who, whatever his status may be as a truthful witness, was undoubtedly a member of the Mungiki, ends with the numbers 218. He was around both Nakaru and Naivasha on his own account when violence broke out. And that witness accepts that this telephone, 218, was his. Between the 4th and the 21st of December, the telephone data in possession of both the defence and the prosecution shows that there was contact between former witness 12 and Mr. Kenyatta's telephone on 6 separate occasions. What was the government minister and future president talking to the Mungiki member about? The telephone number being used by one of the MPs that I have referred to previously was in contact with Mr. Kenyatta's phone on no less than 39 occasions in the months of December and January. Perhaps some contact between a minister and MP is unsurprising. What is surprising is that the contact between that MP and Mr. Kenyatta spikes. When one views it in graph form, it takes a sudden upturn in the 3 days before the violence in Naivasha, in which that MP is said to have been involved. Of the total number of calls in January, something like 1/3 took place in those 3 days. Was that just a coincidence, or was the MP getting instructions on how he should proceed? The prosecution doesn't know the answers to those questions, but they raise uncomfortable suspicions. The obvious way to investigate those suspicions is for the prosecution to gain full access to the telephones being used by Mr. Kenyatta at the time. That is what the prosecution has been prevented from doing by the non-cooperation of the government of Kenya. The prosecution doesn't accept that the 891 number can possibly have been the only number used by Mr. Kenyatta. As a wealthy man and a cabinet minister, he must have had access to many phones. There is every reason to believe that the data from those telephones is still available and would reveal connections of relevance to the prosecution's inquiries. There must be records available to the Kenyan government which would reveal what those numbers are. The prosecution doesn't know. If the Kenyan government was genuinely using its best efforts to comply with our revised request, it would find and disclose those records, and it would ensure that the telephone companies conducted appropriate searches. As Madam Prosecutor has said, the prosecution has looked carefully at all of this evidence. It gives rise to considerable suspicion. It completely destroys any suggestion that there is no case at all against Mr. Kenyatta. But the prosecution recognises that suspicion is not enough. Looked at critically, as we have made plain many times now, this evidence alone is insufficient to provide a reasonable prospect that you will be sure. In the absence of the kind of confirmation which might have been provided if the government of Kenya had abided by its treaty duties, the prosecution recognises that it cannot take the case forward. What it urges the court to do is to mark the fact that those investigations have been stymied by the government of Kenya by making a finding that this case should be adjourned rather than withdrawn. Thank you for your attention.
Thank you very much, prosecution. Legal representative of victims, again, please stay within 15 minutes.
Thank you very much, Madam President. Start with President Bashir of Sudan. He has a right to trial without undue delay. He controls the government of Sudan. That government will not arrest him in violation of its obligations under international law. Is it unfair to keep the charges in place against Omar Bashir? Of course it is. The accused controls the government of Kenya, which withholds key evidence of direct relevance to charges concerning vicious crimes. It does so in violation of its obligations under the Constitution of Kenya and under international law. Is it unfair to adjourn until Mr. Kenyatta executes his responsibilities under the Constitution of Kenya and orders his government to comply with its international obligations, and specifically to comply with Your Honour's unanimous decisions of the 31st of March and the 29th of July? It is not. In the prosecutor against Vojislav Šešelj at the ICTY, a decision was given on the 11th of February 2009 called the Decision on Prosecution Motion for Adjournment. There was a dissenting opinion attached to it. In it, the trial chamber said that it was aware of the impact that an adjournment of the hearing of the last witnesses would have on its ability to try the accused within a reasonable time, but it held by majority that its duty to preserve the integrity and fairness of the proceedings must prevail over time considerations in light of the exceptional circumstances of this case. That case concerned intimidation of witnesses. This case concerns, in my submission, obstruction of justice. Everything we heard yesterday from the government of Kenya, when read in the light of the correspondence between the government and the prosecution in the last few months, and in the light of the positions adopted by the government in the Ruto case, at the Assembly of States Parties, at the United Nations Security Council, and at the African Union, is confirmation that the government of Kenya consistently takes positions which are aligned with the interests of the accused in both Kenya cases, and specifically Mr. Kenyatta. This has been a long and bitter campaign of attrition, the ultimate aim of which has been to see this case collapse. If the trial chamber terminates this case, it will have rewarded that long campaign and those responsible for it. It will have forced the victims and not the accused to pay the price for obstruction of justice. This is a unique case and it requires a unique response. But in a broader sense, this case offers lessons to others. If the trial chamber terminates this case, others will draw the conclusion that a prosecution at the ICC can be effectively undermined through a combination of bribery, intimidation, and unlawful obstruction of access to evidence. If the trial chamber terminates this case, it will generously reward the government controlled by the accused for its refusal to comply with Your Honour's directions given at the end of March and at the end of July, and for its many violations of Part 9 of the statute. Some might say that in any case, a price must be paid for the fact that the prosecution does not have the evidence that it needs. But in this case, who should pay that price? Should it be the victims, whose quest for justice has been cruelly frustrated both in Kenya and before this court? Or should it be the accused, who is the principal author of the deadlock in this case? Your Honours, it would be unfair in my submission to compel the victims to pay that price for the government's non-compliance with the trial chamber's directions and for the government's deliberate frustration of a quest for all the evidence which is necessary to uncover the truth, a quest which should be shared by all in this case. For this reason, I strongly encourage Your Honours, if you do not wish to make an adjournment sine die, to adjourn in order to give the Assembly of States Parties the opportunity to exhaust its own procedures in order to see if it can bring compliance by the government of Kenya. One of the most troubling aspects of this case has been intimidation of witnesses. In the meetings I have held with victims, they very frequently raise this issue. They want to know what the court is doing about it, given its potentially devastating impact on the administration of justice. The prosecution has publicly made allegations of interference with important witnesses in this case, including witnesses 4, 11, and 12. The victims, I suggest, are entitled to know who interfered with those witnesses, at whose instigation, for what reason. And I wish to re-emphasise the importance, for Your Honours, if I may, of paragraphs 92 to 95 of the second updated prosecution pretrial brief of the 26th of August 2013, and take the assertions set out in those paragraphs into account in determining whether the correct remedy really is to terminate this case. Your Honours, the defence has placed great weight on consent provided by the accused. I wish to draw Your Honours' attention to the conditionality of that consent. Yesterday, at page 38 of the transcript, the defence referred to consent being provided for bank records, vehicle records, telephone records. Now let's take those in order. In respect of bank records, in the letter of consent which was provided to us last night and earlier on the 10th of September, there is repeated reference, and I don't believe I'm violating the confidentiality of that letter, to relevant archived bank account records, relevant banks, relevant material. My learned friend Mr. K said that he had provided consent to disclosure of 3 months of bank records. This is yesterday at paragraph 39. Quote, relevant to the case brought against us. It was relevant to the evidence that was relied upon and not some other case, unquote. Now, at the 9th of July status conference, the defence suggested that certain information was not relevant to the case against Mr. Kenyatta as, quote, it doesn't feature in the pre-trial brief anywhere or the DCC. And I refer to the passage in the transcript of 9th of July at page 7, lines 13 to 24. Now, it is clear from Your Honour's decision of the 29th of July that Your Honour's concept of relevance of material in this case is different to the defence's concept of relevance in this case. Setting aside that Your Honours, for example, never suggested that relevance depends on whether a particular subject features in the DCC or in the pre-trial brief. Now, on telephone records, it's clear from the filings made last night, that's filing 964, by the defence, and from the prosecution's submissions yesterday and today that the prosecution has one number relating to Mr. Kenyatta. It was not provided by the government of Kenya nor by the defence. There has been no consent by the defence to the delivery of any telephone number relating to Mr. Kenyatta or his close associates. I invite the defence to correct me if I'm wrong on that. The third category is vehicle records, a little less controversial perhaps. We see from last night's filing that no consent has been provided by the defence as it was deemed unnecessary for the reasons set out therein. In summary, there was no consent provided by the defence for the disclosure of telephone or vehicle records associated with Mr. Kenyatta. There was consent for 3 months disclosure of banking records, but only for such records as the defence believed to be relevant. And I invite your honours to inquire further with the defence as to what it considers to be, quote, relevant, unquote. Mobile telephone data is at the heart of this case. It would certainly help to clarify what prosecution witnesses have been saying. The good thing about mobile telephone data is that you can't bribe it and you can't intimidate it. The Attorney General has said repeatedly yesterday, pages 7, 18, 46 suggestions were made, that there was no compulsory data capture prior to 2009. Now, whether or not data was required by law to be captured prior to 2009 is not the point. Whether it is still available is the point. Activities undertaken by the defence, as confirmed in last night's filing, to obtain cell phone and cell site data from late 2007 and early 2008 confirm that such data is available and it can be obtained by application to the High Court of Kenya. Now, I wish to reserve the position of the victims in respect of the accuracy of information provided by the defence, but I do note that relevant information relating to retention of 2007 and 2008 records does appear at page 7 of Annex F to Defence Filing 878 of the 13th of January 2014, and it also appears in Annex D to the filing made last night. I wish to re-emphasise the critical importance of this category of evidence. If the accused truly wished to clear his name in this case, he would have done whatever he could to ensure that all cell phone and cell tower data from the period of the post-election violence relating to him and his associates was disclosed as soon as possible. This would be one of the fastest ways he could take action to clear his name. He can still do so. The time period for turnaround and disclosure of telephone data mentioned by the Attorney General yesterday at page 23 was 72 hours. I would hope that we can let those 72 hours begin as soon as possible. Your Honours, I was rewriting some of my submissions. I believe I've come to the end, but I would again emphasise, Your Honours, the critical core of my submission is it really fair to force the victims to pay the price, given what they've gone through? They have lost mothers, fathers, brothers, sisters. They have been repeatedly raped. They have been set alight. They have lost their small businesses in Naivasha and Nakuru. They have received next to no compensation from the government of Kenya, and there is no accountability in the Kenyan courts. Is it really fair to force them now to pay the price for obstruction of justice by Mr. Kenyatta's government? Thank you very much.
Thank you, Mr. Gaynor. Mr. Kay, you have 15 minutes.
Thank you, Madam President. Well, everything I've heard in the last 30 minutes confirms my application in the justice of an acquittal being entered on the record in this court. What you heard from the prosecution was a scandalous misrepresentation of the quality of their case, as well as the reasons for not pursuing this case. In our submission, that is the reason why, in circumstances like this, a man who is innocent until proven guilty is entitled to have a record against him to show that those who accused him failed to prove their case or have a case that they thought worthy to bring before the court. If the quality of the prosecution evidence was such as it claims to be, why didn't they go to trial? They didn't go to trial because there were fundamental problems throughout that case, not only the person who provided a number of those witnesses cited this morning and his involvement in the proceedings that I cannot mention, but the whole circumstances of evidence gathering as well as the production of evidence through alleged witnesses was one that utterly failed to meet any acceptable standards. I'm not going to be diverted here, though, into discussing other matters, because the plain issue before the court is one of the future conduct of this case based upon the cooperation of the government of Kenya. Have they, in the intervening 6 months, produced evidence upon which the prosecution can rely to go further with these proceedings? And what is troubling here is that the prosecution have ignored the plain answers to their questions, which they say could have helped them in the examination of their evidence to provide some sort of case. The company records that they seek, and I'm referring here to the tabulated list at paragraph 15 of the filing that was made 943, which is a useful, ready reckoner of the issues before this court today. The company records that was simply answered back that the information that they sought could not be supplied because of their system. If the prosecution wanted to know about a company, the system would be name that company or the registration number. Notwithstanding that, the company records of Kenya have been searched in relation to specific districts that could well have been of interest to the case, and they provided a negative result in relation to the areas considered for the question asked by the prosecution. In our submission, this is a matter that this court should properly take into account as to the nature of the response, what was requested, whether it was able to be performed, and the answer that was given. Land registry records. The search has been done in relation, and I'm sorry, I've got this the wrong way around. It was the land registry where they made certain checks, and I take that matter back. And they could not find in the land registry districts the particular information. In relation to companies, it was supply us with the details so that we are aware of it. In relation to tax returns, the letter that was supplied by the particular tax office was this: all records have been supplied. The data that you seek cannot be supplied. We cannot fulfill your request. In relation to vehicle registration records, the material aspect that could be complied with was open-ended aspects, such as the regular use of other cars that could have provided some sort of evidence to the prosecution, the office could not supply that information. In relation to the bank records, I supplied 3 months of relevant evidence in relation to the accounts of the accused. That evidence was relevant to the points raised by Mr. Gumpert this afternoon as to his witnesses claiming certain facts. There is no support in that evidence at all for the allegations that have been made by those witnesses or any other witnesses. The reason why further accounts are required, and I haven't supplied them of my own volition, is that so-called comparative purposes are needed to assess the evidence that was supplied. In my submission, that is a complete and utter smokescreen. The evidence that you had countered the allegations that you made, and there is nothing within that evidence that supported the prosecution case. Again, foreign exchange records. That request was complied with. Telephone records. The prosecution have known, as I demonstrated in the filing made last night, for a long while, since we first went together to seek the telephone data records, that the whole system was a numerically based system. That is why no names were supplied in relation to that matter by their investigator, by their counsel, in relation to the meetings that took place with the telephone companies in Kenya. So the best evidence has been supplied. And again, I am not going to supply further telephone numbers. I make that entirely clear. And the reason is, every time the defence supply evidence, the prosecution seek to go in another direction. And I have drawn a line in relation to our personal cooperation for the provision of evidence. We got no credit in relation to the matters that we did supply. We got no credit for the data that revealed their witnesses were not at the places they had claimed to be. And that fact has not been acknowledged at any stage by the prosecution. We have undertaken a considerable amount of work over the last 15 months attributing telephones to particular witnesses that proved they were not at those places he's claiming to have been at in relation to the statements relied upon by the prosecution. So in our submission, I have drawn a line in the sand. I do not have to provide any further evidence. We, in many respects, have not had trust in the court and the prosecution. And I'm not saying that in an abusive way, but because when evidence was produced by us that went to the integrity of key witnesses, we were ignored. We weren't relied upon. Our evidence was just dismissed. So for my part, that has had a great influence on my conduct of this case on behalf of my client. When we revealed at the confirmation hearing about witness 12 and witness 11, who had come to us and sought money, all our criticisms there were ignored. The witnesses were still relied upon. The witnesses ensured the confirmation of charges. And those witnesses eventually were withdrawn, and those witnesses have completely gone back on their statements. When we informed the court of the enormous contradictions in the statements of witness 4 as to the content of what he was saying, that was all ignored. So, for my part, in relation to supplying evidence to this court, we are used to being regularly ignored. We provided 3 months of bank accounts, and we have had no acknowledgement that they do not support the prosecution case. The fact of the matter is, if there was anything in there that relied upon by the prosecution to support its case, it would have been relied upon. And so we come to this. Has the intervening 6 months produced material and evidence to satisfy the prosecution's inquiries? In my submission, it has. And a line is entitled to be drawn now under the conduct of this case against Mr. Kenyatta. He is entitled to his verdict of not guilty because this case has not been brought. There are no further inquiries going on. It is plainly not the case that was brought against him that can be sustained at all. And so when I say there is no evidence, I say deliberately there is no evidence, because if there was evidence, we would have a trial. Those are my submissions.
Thank you very much, Mr. Kay. And that brings us to the end of the matters to be discussed today. We thank the parties and participants, Mr. Kenyatta, very much for their contributions. And I would also thank the court officers, interpreters, court reporters, and all other courtroom staff, as well as other court staff outside the courtroom for their assistance. The status conference is now closed, and we will rise.
All rise.